Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Hi, welcome back to What to Do When, a dummy's guide to the legal verse. Scott Cardani and Jackie Critzer here at Critzer Cardani in Richmond, Virginia.
Jackie, what's on the docket for today? I almost forgot what I was doing.
Today, it's what to do when you are trying to have an uncontested or a no-fault divorce, and whether those two are the same thing or different.
Okay. So let's just talk about it. So what does that mean, uncontested, no fault? What's that vocabulary mean?
I think sometimes people think those terms are synonymous. They're really different, and let me just tell you why. Uncontested divorce means, okay, we're not fighting over grounds. We agree we've been separated for a period of time, which we'll talk about. And we've also made an agreement as to all property and money and kids, if there are any, retirement, it's debts. All those things are agreed upon, uncontested, fully uncontested. You're good to go. No fault really is just a piece of that. No fault means no one's alleging any grounds. No abandonment, no adultery, no cruelty.
And that's always based on a period of separation, correct?
Right, absolutely. So no fault is just there's no fault grounds,
exactly.
and requires a period of time to be separated.
And this gets everybody confused. And I think maybe the simplest way to say it is this: you're required to be separate and apart for a year unless you have no children and you have a property settlement agreement already worked out.
So many times I get the phone call, well, I thought it was only 6 months. Well, it is 6 months if you don't have kids and you have a separation agreement.
Yes.
Otherwise, it's a year.
Otherwise, it's a year. So think of it that way. So if you can get with your spouse and work out all the property issues, the equitable distribution, as we call it, issues, then you may be on the 6-month track. But if you can't, then you're on a year track. And again, we talked about this earlier, but the hardest part about this is how do you start the separation? And we talked about that in another podcast. But it's really important. Somebody at some point, most of the courts don't consider separation you being in the same house and living out of the same checkbook and doing all those things. There's a lot of points to that, and we've already discussed that, and we may discuss that in the future. I don't want to get bogged down in that, but that's really important. So you have to know there's two different things we're talking about. If you truly have an uncontested divorce, you're coming to us and saying, look, we've worked out everything, kids, cars, money, retirement, everything. All we need is an official document saying we're divorced. That's uncontested.
Right. No
fault is we're not blaming each other. We've grown apart. We've been apart for a year or 6 months, and we separated everything. And that's another grounds that gives you the right to file for a divorce. So that's what gets you into the courtroom or gets your case started to file it.
Right. Well, and I had a train of thought and went right down the track.
So we probably should cover a little bit real quick what a PSA is, property settlement agreement.
Is that the same as a separation agreement?
It is. And what all that is an agreement between the two parties. And, in a day we'll do a little in-depth dive in this. It's not proper for here, but bottom line is it's an agreement. It's a contract between two people that they have set down, and there have been cases where it's been on a napkin.
Sure.
And you both agree that we're going to do this with our retirement, we're going to do this with a house, we're going to do this with the cars, we're going to do this with Johnny and Jill, and we're going to do this with anything else, furniture in the house, all that stuff. So you've worked out everything. We're agreeing to all this, and sometimes lawyers can help get that done and get a property settlement agreement done. It's always a really wise thing to do because litigation costs are really high when you start fighting over who gets the records and who gets the phonograph and all those kind of things. So it can really be an expensive process that way. So if you can work out those things or work out as much as you can, that's always the best practice for your sake.
And I'll say too that there are, just like in every industry, there are attorneys who are going to try to take advantage of the situation. They're going to draw up a mostly one-sided document in hopes of driving up attorney's fees. It's important to really pay
That happened?
I've read some that seem to have been drafted that way. It's important to me when I'm meeting with my clients to really emphasize that I'm not going to draft a document that is so one-sided that, number one, a court's not going to entertain it, and number two, that it's just going to end us in more legal fees. It's really important to try to draft it with the end in mind, and that is eventually, property is divided. 5 years down the road, you've been divorced for a period of time. What does your recovery look like? And so it's not just today. What do I want to do today? Because we have those clients too. We're like, I don't care. Just give her everything, or just give him everything. I just want to get it out. But it's part of our job to help you remember that there will be a time when the emotions are less charged, and you are going to wish that you had asked for part of his retirement or part of her retirement.
Or the big one is sometimes spousal support. You think you just want to be gone, you don't want to deal with spousal support, and then a year and a half later you're struggling to pay your mortgage, and you're like, man, I wish Jackie didn't advise me right. I should have got spousal support. And all your friends are saying, why didn't you get spousal support? Well, you're not going to go, oh, I just thought it was a good thing not to do it. You're going to say, well, Jackie did it. She didn't tell me to do that. So we really try, again, this whole approach is to really listen to you and to craft whatever we craft that's going to benefit you. Jackie's right. We don't want to get so one-sided it's ridiculous, but at the same time, we are going to draft it in your best interest. That's the whole point of this. So, you have to look at the total, and I always look at it this way. You're looking at whatever was created during the marriage is subject to separation and a divorce. So I look at it as a pie, in the sense of, there's a lot of ingredients that went into that pie, a lot of different things, and what we have to do, the assumption going in is that pie will be split 50-50,
right,
and each of you get a half a pie. And that may not be the case in the end, but that's where you start, and you look at all those things, and then why wouldn't she get half the retirement? What would be a hindrance to that? Why why shouldn't I get spousal support? And those are the other factors. And when you're in a no fault, as we're talking about here, adultery and those kind of things that go against splitting the pie equally are gone. So there's no argument for those things. So really you're dealing with pretty clearly a situation where you're saying there's no fault here, so most likely you're going to be in a pretty even split.
And so it wouldn't make a lot of sense to file an uncontested divorce and then go to court and fight over property, money, retirement, things, mostly because a court's, like Scott just said, it's just going to divide it pretty well down the middle. And I mean, if there was a fault ground, if there was a reason not to, then there'd be a different story. So we don't see that very often. Most of the time, a no fault is in fact also an uncontested divorce. And the best way to accomplish that is with an agreement, a written agreement. Now, there are rules and statutes that support marital agreements and what needs to be in them and what shouldn't be addressed in them, who can write them. And Scott's right, it can be on a napkin. It can be between the spouses, just they can write it themselves. I will tell you though, I've seen some of those homegrown, or I pulled this off the internet, sort of property settlement agreement or separation agreement, and they're not robust. They're not thorough. Sometimes they don't even cover some of the basics. I have one that I've been looking at recently that even they pulled it off the internet. One of the parties did, and it says something to the effect of, "This isn't the final agreement, and it will not be incorporated into the divorce. We're going to agree in a future agreement." And I thought, oh boy, this is bad. This is setting the parties up for very expensive litigation,
Yes.
Which is now what I'm involved in.
Yeah, you just have to, again, it seems to make sense to want to cheap it and do it simply, and especially, you don't want to be paying us for something, but at the same time, you should sit down, even if your wife, you come home and your wife hands you a separation agreement today, we're done, we've been done for a long time. Take the time to take it to a lawyer and don't go to a lawyer and go, hey, read this, is it okay? Because he doesn't have any of your financial documents,
Sure.
He doesn't have anything. So you really do want somebody to look at it. I mean, if you don't need to give them every piece of paper, here's my bank statement for 10 years, but you may want to have a nice summary. Here's what we have in retirement. Here's what we have in savings.
Absolutely.
Here's what we have cars-wise. Here's what our mortgage is and what's left in the we own our house. We own 17 business, whatever it is. You want us to have a pretty good perspective of what there is, and then we'll probably ask some questions. What about this? Oh, I didn't think about that. you know, a lot of times people forget about like cars because they both had their own cars for years and they don't really share cars, and they're like, you still should put it in the agreement just so there's not problems. And then maybe it's titled, how things are titled matters, you know, whether it's titled in parties, both names, or all those things. So, you know, our point is, no faults. You see a lot of no faults for $50 or $100 on the internet, and you know, I don't know though. I'm not judging anybody in that. I'm just saying sometimes you get what you pay for. You know, you really need somebody who's going to sit down with you and look at your full situation, even in a no-fault divorce where you're saying, look, this is just us. We got to the end of the road and we realized we're not compatible, you know, or I'm not willing to work on it, whatever the case may be. That's usually more it. But, you know, we need help getting this separated, and just make sure you walk through all the issues. You know, my wife doesn't want to get an attorney. We don't want to spend the money on an attorney. That's okay. But even in those situations, I kind of advise, you know, she should have somebody look at it. You know, she can choose not to, but she should have somebody look at it.
So I was just about to head down that road about representation. So first and foremost, it's important for everyone to understand that we can't represent both the husband and the wife.
Yes.
That is a major, major no-no. The Virginia State Bar would come down on us really hard, even if you agree for everything. Oh, we have it doesn't matter. I cannot represent both of you because I can't look out for both of your best interests. It's like a dual, when a realtor does the buy and the sell, they can, but they can't really be effective for both. They're sort of somewhere in the middle, and we're called to a higher standard than that in the legal profession. But when I draft an agreement, okay, and I say, okay, here, take it, and they say, well, do they have to have an attorney look at it? Of course they don't, but they should. Because, and if you're receiving that, right, you guys decided that he's going to go and he's going to pay for the lawyer and he's going to have his lawyer draft it, and you're looking at it, and should I talk to an attorney? Yeah, you should. Absolutely you should. Even if you had everything agreed to, you need to make sure that it adequately and accurately reflects the agreement that you thought you had, because what if it doesn't?
Exactly.
And you sign it.
Yeah, you know, what if there was one, you know, I honestly don't find this as much, but when I started a long time ago, I would find a lot of little tricks in agreements, like phrasing is a certain way to flip the words, like you agree that, what was the one I'm trying to think of? Even spousal support. There's some specific language that you forever waive spousal support. And one of those words being flipped in there the wrong way could make it say that you forever agree to spousal support just the way it's worded, and all of a sudden, what you thought you signed, you didn't sign. So I have to say, in the last 10 years, I've seen very little of that. When I first started, I used to see a lot of it, quite frankly. I'd have to read everything, like, not that I don't read everything, but I mean, I was looking for that. I was looking for it, and I still do, quite frankly, because I was so bothered by it at the beginning of my years of practice. So you got to be careful. You may read something that you think is legit, but legalese may be in there that may totally turn on its head what you think is a simple agreement. But it is. That's the other side. I would say it's important to keep it simple. You know, I think sometimes when you get too verbose in language, the judge looks at it 2 years later and says, I don't know what the heck you all were saying. There's just too much there.
Well, that's a good point. It does have to be clear. The reader needs to be able to understand what the agreement was, because the reader, the judge, is interpreting it. Let's say it's a contract provision, and I know we've gone down this rabbit hole of PSAs, but it's important. Let's say there's a provision, and at the time you drafted it, you and your spouse are scrawling it out on your legal pad or your napkin, whatever it was, and you thought you understood what the other person meant, but it's not clear in the words and the writing.
Yeah.
The judge is the one who gets to decide that, and well, depends on the day, depends on the judge. So it is important to have someone who is skilled in the drafting of agreements. But I wanted to also point out that you can also include custody, child custody,
Absolutely.
both legal custody, physical custody, child support. These all of these legal matters that we talk about in our podcast don't have to go to court and be litigated. We don't have to go fight. You don't have to go spend the thousands of dollars that it costs to do that, sometimes tens of thousands of dollars. You can reach an agreement. It's not always possible, but you know, and I love going to court. I think we love going to court. That's just part of what we do. But most of you people watching do not enjoy going to court, and there is a way to avoid it. But if you don't have a skilled attorney on your side to both advocate for you in court and also help you stay out of court to the extent possible, you're really fighting an uphill battle that could leave you bruised and battered for a long time.
Yeah, and quite frankly, even if you don't like that the marriage is ended, being fair and trying to be fair-minded about how to resolve it is, quite frankly, always your best step, because it does, save you a lot of litigation costs. Now, if you're in a position where you don't mind that litigation cost and things like that, but some people, I have literally seen cases where the total assets are $20,000 and they pay in the lawyers both $20,000, $25,000, and so they're in the hole $20,000 or $30,000, and they got nothing. They got zero. In the end, all they got was debt. And I'm like, it's painful for me, because I hate to see that for people. So again, you got to look at what you have, what's worth fighting over, what are the things that are important, and really sit down and have that humble conversation. Don't work out of the anger that the thing is ending, and you don't like how it's ending or any of that part. And that's important. You have to emote that. You have to deal with that. So I would deal with that before you sit down to go, okay, what's a reasonable agreement and how's that going to look? And then you come to us. So I guess the takeaways today for a no-fault divorce is there's two things. There's a no-fault divorce and an uncontested divorce, and they're both statutorily driven, but the bottom line is both of them have to be a year unless you have a PSA and you have no children.
Absolutely. A PSA helps you stay out of court in totality. So that means you've had a property settlement agreement or separation agreement that goes with your no-fault divorce, which makes it entirely uncontested. And that includes all matters from the marital estate, custody, support, cars, houses, retirement, every aspect that could be included in a contract is then included in the agreement.
And finally, you can go with a no-fault divorce and still go to court if you think there's some issues that doesn't mean you have to avoid court or be fearful of court, because there may be a retirement issue that you think needs to be litigated. He's not willing to agree to 50% of his retirement because he says this, and this, and maybe that's something that we have to, or the custody piece or one other piece needs to be litigated. That's okay. We can do that in an uncontested posture. That doesn't mean that we have to allege adultery to get there. We can go to court. You're separated a year and say, okay, these are the things we agree on, and maybe it's nothing, but maybe it's we agree on these things and we don't agree on these things. And usually, if we have a competent lawyer on the other side, they're pretty good about, we do what's called stipulation sometimes, and they're like, we agree to these 10 things, but we don't agree to these 4 things, and judge, we need you to decide.
Absolutely.
Thank you. Have a great day.
Be sure and look for us on wherever you listen or watch your podcasts.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer Cardani.